So today I'll be giving a practical introduction to intellectual property, and I'll give a quick overview and then we'll take some questions at the end. So the overview is, we'll be talking about patents, which you can use to protect inventions, and I'll explain a bit more later on about what inventions are and what inventions are patentable. Designs for protecting the appearance of products, and trademarks for protecting your branding. And there are a number of costs mentioned throughout the slides just to give you ballpark figures and general expectations. In reality, they'll always vary from case to case, but hopefully it will give you an illustration at least. And also as we go through, I'll be trying to plant some red flags in your mind. So when you have certain thoughts or come across certain problems in setting up your business plan and running your business, when a red flag should be waving and you should be thinking, I need to make a conscious decision about intellectual property now. So, to start with patents. What is a patent? Well, a patent is a deal between the inventor and the state. The inventor's side of the deal is he or she must tell the world how to work their invention and what their invention is. And the principle is that by telling the world and publicly disclosing what your invention is, other people can learn from it, build on it, and the technology moves forward and innovation continues to happen. In return, the state will give you a monopoly for a limited period of time, up to 20 years in almost all countries, during which you can stop others from working your invention. So that's the deal. And it's important to mention that patents are territorial rights. So if you only have patent protection in the UK, and the UK is the only country coloured in blue there, that will only enable you to stop people doing things in the UK. So you could potentially stop somebody from manufacturing in the UK and selling in the UK, which is the circular red arrow. Potentially you could stop somebody from manufacturing in the US and shipping into the UK or importing into the UK, and that's the red arrow crossing the Atlantic. Similarly, if that red arrow was reversed, you could potentially stop people manufacturing in the UK and exporting to the US. But what you can't do with a UK patent, for example, is stop people manufacturing in China and selling in France, or any other combination of countries that doesn't involve the UK. Now you'll have the option to pursue patent protection overseas, and we'll talk about that a bit later. And very often at the outset, companies can get quite excited saying, I want to protect this all over the world, everywhere is important. Clearly there's a cost implication there. And in reality, it's not uncommon for companies to choose just a handful of key countries, perhaps manufacturing bases, key commercial countries where they expect their sales. But you are likely to want to be picky in your choice of countries because of costs. So why do I want a patent? There are a number of reasons. So if I hear people say, I don't want a patent because it will cost me a fortune to enforce against people, I don't think they've considered everything they should be. That's not the only reason to get a patent. And in fact, very, very few patents are taken to court and enforced. It can be expensive to do so, although there are various procedures in place to try and limit those costs, especially for SMEs and small claims. But it's not the only reason to have a patent. So bullet point number one, I've said to keep competitors off the grass. That could be by enforcing your patent. It could keep your competitors off the grass without you knowing. You'll never be able to see something that somebody else didn't do because of your patent. And it's important to mention, because this crops up quite regularly from people who are unfamiliar with patents, that getting a patent does not guarantee that you can work your invention. Having a patent gives you the right to stop other people working your invention. So I can step through an example to illustrate this. If we can imagine seats, benches, chairs are not known, they've never been seen before, and person number one comes along and invents a bench. Says, I've got this great idea. I've got a platform on which I can sit. It's supported by 4 legs that keep it off the ground, and I want to protect that with a patent. And we'll assume that they can get a patent because that's not been done before. Person number 2 comes along and says, well, that bench is great, but after a few beers I keep falling off the back. So what I need is something to stop me falling off the back. And they invent, let's say, a chair with a platform at the back that you can lean back on. Now, if person A has got patent protection for a bench, and they've defined their bench as a platform that's kept off the floor with 4 legs, and person number 2 comes along and makes a chair which has a bench kept off the floor with 4 legs and a back, if they then commercialise that invention and they put it on the market, they could be infringing person A's patent for a bench. Now, person 2 could also get a patent for their chair, because that's never been done before. And indeed, if person number 2 has got a patent for their chair, that puts them in a much stronger position than if they didn't. Because if person number 1 comes after them and says, hang on a second, person number 2, you are doing things which infringe my patent, give me some royalties, please. Person number 2 could be in a strong position and say, well, actually, I've got a patent for a chair. Let's do a deal. I'll grant you a license under my chair. You can go away and sell chairs. I'll sell benches. We won't sue each other, or we'll grant each other licenses and take royalties from each other's sales, and therefore we can both benefit from that. And this also illustrates a key point. The person number 2 could come along and say, well, actually, your patent says you've got to have 4 legs keeping your seat above the ground. I'm only going to have 1 leg. I'm going to have a bar stool, and therefore I don't infringe your patent at all. And that will, I'll follow through with that example later on about how it is important that you protect your invention in the broadest way you can. Because person number 1 could potentially have said, well, actually, my bench doesn't have to be a bench. It could be any platform that's held above the ground by 1 or more legs. And then they could have caught the bar stool that came later as well. A second reason you might want a patent is if you want to sell or license your invention. By having that tangible right, that can be much more appealing to people who want to buy your invention or your company, and equally something to grant a license under. A patent can, and I've seen this many times, greatly assist with funding. Many investors will look for tangible rights in the company that they're looking to invest in, and a patent and other types of intellectual property can add value to your company and can also get investors on board, because you have potentially safeguarded your position and the effort you've put in coming up with an invention. To improve bargaining power and cross-licensing is the example I talked about earlier. And also many companies, or a good number of companies, will benefit from patents and other intellectual property in their marketing materials to show how innovative they are, to put numbers on documents. Say we've got hundreds or thousands of patents, and that can be useful as well. So, what is a patentable invention? Before I can explain it in more detail, I think I need to say that an invention is defined by a claim, which is in the patent document. It's a single sentence that defines your invention, preferably in the broadest way you can, in a way that is novel and inventive. And we'll talk about novelty and inventiveness shortly. So the importance of getting this claim right is paramount. With the example earlier in the bar stool, if person number 1 had defined their invention more broadly than having 4 legs and said it has 1 or more legs, then they would be in a stronger position, probably. Now, what do I mean by novelty? Novelty should be a black and white test. It should be a yes/no answer. Has it been done before? Or has the invention been publicly disclosed anywhere in the world in any form? So it could be a written publication, it could be a verbal disclosure, it could be an exhibition or something being shown or put on the market. All of these things can count against you for novelty. And in order to be novel, you must have just one difference. So the example I've put up there are 2 trikes. If we imagine the green trike is what's been done before, what's known to the world, and that's sometimes called prior art, in the sense that it is the state of the art prior to you making your application for a patent. And let's say your invention is the pink trike. Now there's one clear difference in novelty there, which is the colour, and that And if you claimed a pink trike, you should be novel over the green trike. It's a black and white test. It's a binary decision. Now, there could also be other differences that we can't see in this picture. So it could be that your pink trike has some improved bearings, perhaps, between the wheels and the axle. That could be another difference, and I'll explore that a bit further shortly. It could also be that the rubber you use for your tyres is different. So let's say we've got 3 points of novelty in our pink trike over our green trike. The next question a patent office will ask in trying to determine whether or not your invention is patentable is that difference inventive, or in other words, is the difference not obvious? So to take our first point of difference, the difference in colour, I expect we would struggle to say that that difference in colour was an obvious difference over the prior art. We might ask ourselves, well, why is it different? Assuming it's for aesthetic reasons, what's standing in the way of somebody who makes green trikes, making them pink? Probably very little, and if it is very little, I'd suggest that's probably not an invention, because it's an obvious difference over the prior art. And as we'll see shortly, this inventiveness argument is very much a grey area. So novelty is black and white, inventiveness is very grey. Now if we move on to the bearings, let's say that the bearings we're using have never been used in trikes before, but they have been used in motorbikes. Now we have to ask ourselves, well, is it obvious to use motorbike bearings in kids' toys, trikes? And to answer that question, we need to put ourselves in the shoes of a fictional, skilled person. Somebody perhaps with an undergraduate degree who knows about the area of technology of the invention. So let's say it's somebody who makes kids' trikes with a degree. We then need to put ourselves in the shoes of that person and say, well, if I'm looking to improve the wheels and the bearings on my trike, would I look to this different technology space of motorbikes and use technology from motorbikes in my trike? I'm not going to be able to give you a yes and no answer, unfortunately, but there could be arguments say, well, actually, it's a wheeled vehicle, the bearings are doing the same things as they would in the motorbike. So I could see a patent examiner saying, no, that's an obvious thing to do. The bearing is doing the same thing as it would in a motorbike. They're both wheeled vehicles. They're both similar-ish. You can't have a patent. There may be arguments to the contrary, of course. And then if we explore the third example, that the wheels or the tyres are made of a different type of rubber, let's say that type of rubber were known to be used in making washing up gloves. So if we go through that same test again, put ourselves in the shoes of the person who's making the trike, would they go looking at, would it be obvious for them to look at washing up gloves to improve the quality of the rubber in their tyres on their trike? And here I expect there's a good argument that no, they wouldn't. It's a completely different technical space. Why would the trike manufacturer go and look at washing up gloves? So those are three examples with hopefully an increasing likelihood of being considered inventive or not obvious. For any case, it'll always come down to the facts. And as patent attorneys, we're well used to putting together arguments in our clients in the applicant's favour. And then just to give you a quick idea of things that are potentially patentable inventions, products, devices and apparatus is probably what you would expect, but also processes, including manufacturing processes, can be patentable inventions, as long as they're novel and inventive. And I'll say there are other criteria to getting a patent, but novelty and inventive step are the key ones, or at least usually the first two steps to get over, first two hurdles to get over. Manufacturing machinery, control algorithms, so perhaps for controlling machinery, for controlling your smartphone perhaps, or other computing devices. And software, I think, warrants a special mention, because at least in the IP world, it gets a reasonably high amount of press, a large amount of press coverage. Not always accurate, in my opinion. There are lots of open source people who shout very loudly, and I think I want to put in your mind that patents can be gotten for software as long as it's the right type of software. And this, I could speak for an hour or more on this subject alone, which I'm sure is not suitable for today, but ultimately the test will be, does the software do something technical? So controlling machinery may well be okay, an improved user interface may well be okay, an improved way of displaying images may well be okay. It's doing something in the real world. What probably won't be okay is implementing a business method with computer software, or merely automating something that's already known. But this is a very complicated area in itself, so I don't propose going into detail. But I just wanted to sow the seed that not all software is not patentable, or I guess more clearly, some software is patentable. And then chemicals and pharmaceuticals are also patentable. It's not my technical area, but they are. So a few flags that might, or a few thoughts that might cause a flag to wave. If you've come up with an idea or implementation you haven't seen before, then that could mean it's novel, potentially. So you might want to be making a conscious decision as to whether or not to pursue patent protection. Not to say you always should, but as long as a decision is made, I say that's a good thing. If you have put together two known concepts and found a surprising result, that could be patentable. The fact it was a surprising result could well mean that it wasn't obvious, to come back to the test from earlier. And the third flag I've put there is if you put a lot of effort into solving a problem, doesn't in itself mean that your solution is a patentable invention, but it's probably worth consideration that if you had to put a lot of effort in, again, maybe that's a pointer that it's not obvious, because otherwise you would have done it very quickly, and therefore to protect that effort you have put into solving the problem is filing a patent application good value for money for you. And I've probably mostly covered this, but just to reinforce that software as such, which is what the legislation says, is not patentable, but we need to interpret what as such means. That's complicated, but some software can be patentable. So, before you file a patent application, some things you may wish to do. You might want to perform some searching yourself. It doesn't incur any costs, apart from your own time, and can give you a feeling for what's been done before, and therefore give you an impression of what is likely to be novel in your invention or the product you've developed. And it may enable you to think about inventiveness, but that will be less easy for the unfamiliar. And ultimately, I would say the main likely benefit of the searching is so that your patent attorney can advise you better. If your patent attorney knows what's been done before, or at least has a starting point, they can start drafting your claim to define your invention in a way that is novel over what you know about. If you hadn't done that searching, you might draft a claim for something that had been done before, and that can increase costs later on, and also result in the patent document not focusing on features which you might otherwise have done had you known what was out there before you. And I say it may result in your patent attorney being able to advise you better, because you can prepare and file your own patent application if you would like to. There are downsides, and I've heard it compared to pulling your own teeth. You can pull your own teeth if you want to, but it'll be messy, painful, and very expensive to put right later on. And in fact, you might not even be able to put it right later on. Filing a patent application is drawing a line in the sand, telling the world what you've invented as of that date. If you tell the world the wrong thing at that point in time, you may be restricted to only pursuing that wrong thing later on. You can't add new material later on because you've drawn your line in the sand. That's it. It's really important to get that line in the sand in the right place in as much as fencing off what you have invented and saying the right things. So I've got another flag there. If you're considering filing your own patent application, make sure you're willing to accept the risks of potentially not getting a patent granted or not getting a patent granted with commercially useful scope of protection. And equally, I guess, if you're going to speak to investors later on, if they're going to review the quality and the documents you've put forward, that may well cause concerns for them. And this is the biggest red flag I've got in the presentation. I can't plant it deep enough or wave it hard enough. Don't tell anyone about your invention outside of a duty of confidence. You'll be shooting yourself in the foot because you will no longer be novel. Your invention will no longer be novel. We see it in academic institutions, universities all the time. Inventors and academics are really excited about their invention, want to publish a paper or display in a poster or a conference, and that can result in you either not getting a patent later on, or if you do, it could be invalid. And patent examiners are wise to this. When they search, and we'll come on to that later, to see whether or not your invention is novel or not, they will plug in the inventor's email addresses, names into Google or some other search engine, because they know that is a ready source of prior art for them. So I can't emphasize that enough. If you want to talk about your invention, preferably don't. In reality, if you need to speak to investors or partners, get a duty of a non-disclosure agreement in place. So that's why I've said outside of a duty of confidence. So how do you get a UK patent? Starts on day one when you file your first application. Usually we suggest filing that in the UK because official fees are relatively low, and also because we can get our search quickly. So a general idea of costs would be £3,000 to £5,000 on day one. Within 6 months or so, assuming you've asked the Patent Office to search your invention, and we would generally recommend that, you get your search results. So the Patent Office will send you a list of documents that they consider potentially relevant to your invention as you have claimed it. Now, getting that information before the 1 year stage is really important because it enables you to make more informed decisions later on and how you might want to incur further costs or not. You should be getting an indication of the likely scope of protection that may be available at that 6 month date. And at the 1 year stage, so working along the timeline, that is your deadline for filing any overseas applications which can benefit from your line in the sand that you've drawn on day one. We call that claiming priority. The second application is treated as if it were filed on the same date as your first application, and therefore any public disclosures that have happened by third parties between day one and 12 months later should not count against your overseas applications filed 1 year later. And I've got another couple of slides on the overseas option, so we'll park that for now. 18 months down the line, the Patent Office will publish your application. So up until then, you can still keep your invention secret if you want to. All your competitors will see is the title of your patent application, which we generally keep pretty broad so that you don't give away anything that you don't have to. Of course, you can publish your own invention on the internet or in any other way, should you want to. 2 years down the line, you'll request examination for a pretty nominal fee. And then probably between 3 to 5 years, you will get an examination report from the Patent Office raising objections. You'll go back and say, oh yes, it is patentable because, or okay, so I accept that my bearing isn't patentable, but I'm now going to define my invention as my rubber tyres, or whatever it may be. And typically that may be the same costs again, 3 to 5k. Now, with that time frame, people often comment, gosh, that's a long time, isn't it? Yes, it's not always a bad thing that it's a long time. It extends the period over which your costs are incurred. You can keep your options open as to how you want to finally define your invention in a way that hopefully is patentable, and also keeps your options open for investors. While you have a live application, if they decide to take it on, they could potentially pick and choose the avenue in which they want to define your invention and hopefully obtain a patent. But if you do want to get a patent more quickly, there are mechanisms in place. This isn't available as of right, but if your invention relates to a green technology, and that's interpreted very broadly by the Patent Office, or if obtaining a granted patent will help you obtain investment, or if you are aware of a potential infringer that you want to stop, if you've got a good reason, the Patent Office will speed things up, and potentially you can get a patent granted in less than a year. Now, those two tranches of £3,000 to £5,000 we talked about on slide 1, which were spread out over 5 years, now of course could be spread out over 1 year. So it squashes all that up. It's not necessarily what you want to do, and in my experience is really what clients want to do, and SMEs, but it is available for specific reasons. So getting patent protection overseas, there are two options I'll talk about. The first one is at the 1 year date, when you can file priority claiming applications to pick and choose the countries you want. So I've given some example costs there. You could file a European application to cover all of the EU and other European countries, which will be about £3,000. The US might be 3 to 4, and other countries could be 2 to 4. So you can see that costs can multiply very quickly, very early on. So if you want to, you might say, well, those are my key jurisdictions. Let's say Europe and the US, that's still another £6,000 to £7,000 1 year down the line.
In addition to 3K?
Yes, that's right. So principally at the start, the majority of the costs for filing your first application will be for your patent attorney to prepare the document in a good shape that's suitable for Patent Office prosecution. When you come down the line, although you don't have those preparation costs, you'll have to pay official fees in each country or jurisdiction, and if outside Europe, you'll have to pay locally qualified patent attorney fees. So it's not to be taken lightly. There is an option which many SMEs and companies go for, and that is to effectively buy an extension of time for making that final choice of countries. So when you get to the end of the procedure, you will have paid more, but you will have postponed those costs for the individual countries, and you will have postponed the point in time at which you need to choose those countries. So you can do that by filing an international PCT application at the 12-month date, and that will take your final choice of countries up to 30 months. So you can see there is the additional cost of the £4,000 to £5,000, but if looking for investors, potentially, you have kept your options open. They may have their own ideas as to which countries are important to them or where they see your business going, and you've given them maximum flexibility, but at a cost, but at a financial cost. And I'll just mention, because I've seen on television, Dragon's Den and other programs, people say, I've got an international patent. Strictly speaking, that's not right. Your international application will never result in an international granted patent. That's why I've put that cross there at 30 months. It expires, but it gives you the option to spin it out into individual countries and jurisdictions. I'll briefly mention freedom to operate. If you'll be making a large investment, or if it will cost a lot to change your plans, then you could consider performing a freedom to operate exercise. And by that I mean having a look at what patents are already in existence that might stand in the way to you launching your product or implementing your invention, however you choose to do that. Now, it's not always the right choice, because it can be very expensive. It can be tens of thousands or more. There's a great deal of liability involved for a patent attorney to say, yes, you're okay, or to quantify the risks of you launching your product. There's a lot of work involved in interpreting what granted patents mean, and that's not as straightforward as as I might like to think. And it will never provide a definitive answer, because ultimately a court would decide what a patent, a claimed invention in a patent means, what those words mean, and whether or not they read onto your product. But as I say, if you're spending millions of pounds in building a new fabrication plant, then probably tens of thousands of pounds to understand your risks is good value for money. But for many SMEs, in my experience, freedom to operate exercises aren't good value for money. But it is very much horses for courses. I'll now move on to a different flavour of intellectual property, and that's designs. So what is a design? A design is for protecting the appearance of an article. And the two main aspects of design protection are registered designs, where you take active steps to tell the world what you've invented and register your design. There are also unregistered designs, also referred to as design rights, which occur automatically. You don't need to do anything to acquire those. And you won't be surprised to hear, since you get it for free, there are downsides or disadvantages to that. So designs that can cover the UK, with designs being territorial rights again, of course. Community designs are good value for money. They give rise to rights in all 28 EU member states. They might cost £1,000 to £1,500 for a first design and a few £100 for subsequent designs. And if you compare that with the costs of a UK national registered design, it's about half the cost, but only covers one country. So typically our clients are taking the community design right option as being better value for money. And worth mentioning here again that if you have a number of variants of your design, and I'll talk about what qualifies as a design shortly, it's particularly good value to include those subsequent designs in a single application, because it's only £300 or so to lump them into a single application. And I'll just contrast that quickly with a patent, which can only be used to protect a single invention. So I'll talk about the community registered design mainly, and that protects the appearance of the whole or a part of a product, including surface decoration. It does not protect designs dictated solely by technical function. So for example, you couldn't protect the design of a 3-pin plug, and I think that the principle is quite easy to understand, that it wouldn't be fair for you to protect that and stop other people making a 3-pin plug, which is the only way you can plug your electronic device into the socket in the wall. So any design that is dictated solely by its technical function or is designed to fit with another product is not available for design protection. So how do you get a community registered design? Well, you apply for one. It's a registration process, so in contrast to patents, where a patent office will check if your invention is novel and inventive, here the designs registry will wave it through and you will automatically get a registered design. But in order to be valid, so for example if you try to enforce it, you would have to prove that your design was novel, similarly to patents, and also have individual character. And here the test is that your design creates a different overall impression on an informed user to existing designs. There's lots of words to work out what they mean in there, and lots of arguments to be had, but that's the test, and I won't go into it in detail now. So a little flag here: if the appearance of your product is likely to be an important factor in the marketplace, consider whether a community registered design is good value for money for your business. So we want to talk about timings. Patents can last up to 20 years upon payment of annual fees for patents once it's granted to keep it in force. Community registered designs can last a little bit longer, up to 25 years, with renewal fees kicking in every 5 years. And in contrast to patents, your registered design is not necessarily, or the validity of your registered design is not necessarily destroyed by something you have publicly disclosed, as long as that public disclosure was within 12 months of you applying for your registered design. So you've got this grace period during which you can file a patent application and not have your early disclosure count against you. So if, when you are going to disclose your community registered design, you consider, well, actually, it's not good value for money for my business now to pay that money to register it as a design, you might decide to make a diary entry for yourself for 1 year's time to reassess, because potentially you could file your community registered design application then without your earlier disclosure counting against you. But it has to be your earlier disclosure, not third parties. I won't talk in any great detail about the UK registered design system because it's very similar to the community registered design system. The key difference being it only covers the UK, but it is cheaper. So unregistered design rights. Protection is acquired automatically as soon as a design is recorded in a design document or an article is made to the design. I think it's too much detail to go into, or too much information to go into great detail about unregistered design rights today, but they can last from 3 to 15 years, depending upon whether they are community unregistered design rights or UK unregistered design rights, although typically they only provide 3 to 5 years of exclusivity. And the key downside is that they only provide you with a right to prevent others from copying the design. So you need to prove that they have copied your design, and that's not always going to be easy to do. So it's much more difficult to enforce than a registered design, where you don't need to prove copying, because you've got to prove that it was directly copied, and you have to have kept your records proving your date of creation of the design. So there's a few flags still to come that basically say maintain and keep good records. Here those records are in relation to the date of the creation of your designs. So any notebooks, lab books you have, don't bin them, keep them in a box somewhere, because they could be useful later on. So I'll move on to trademarks now, and there are 2 example trademarks. So why do you want a trademark or a brand? So that customers recognise your goods and services. You can create goodwill and reputation in that brand, and customers can hopefully come back to you because of your brand. Can add value to the business, again, when looking for investment or potentially when looking to sell your business. Marketing PR reasons, just as before, and potentially to assist in any franchising, depending upon your business model. So what is a trademark? Virtually anything, as long as it's capable of distinguishing your goods or services, and it must be capable of being graphically represented. So examples include, and I'll flash up a few slides with example trademarks, words, logos, slogans, colours, shapes, sounds. So colours, for example, I believe BP has trademarked the colour green for petrol station forecourts. Pretty broad protection, clearly, but they built up a reputation in green petrol station forecourts, and now they can stop anyone else making theirs green. I guess more traditional trademarks are words, a few of which are shown there. Logos, slogans, shapes. So Jif Lemon, for example, can stop anybody else providing lemon juice or perhaps any condiment in a lemon-shaped receptacle. So when you're adopting a new brand, what do you need to think about? Well, it should be typically aimed at a specific market, because in different languages your brand could be interpreted differently. So that's something to consider, your markets, and whether a word which sounds great in English might have some unexpected meaning in a different country, in a different language. It should be distinctive, not descriptive, because you won't be allowed to register a trademark that is descriptive, on the basis that it would be unfair on your competitors for you to register as a trademark a red chair and stop competitors selling a red chair and calling it a red chair. And that's clearly what it is. So trademarks should not be descriptive, and they should be capable of distinguishing your products or services from your competitors. and such brands can result in your trademark being more easily registerable, which we'll talk about in a moment. So you will also probably want to ask yourself the question, and you probably should ask yourself the question, am I free to use and register the trademark? Now, when we were talking about patents, I suggested this could be very costly and not always good value for money. Here, clearance searches will typically cost between £600 and £1,000, and once you've launched your brand, you may be quite reluctant to have to change it. All the time your brand is out in the marketplace, you'll want to be building up reputation and goodwill in that brand. So anytime you need to change that brand, you might have to start again in that endeavour. So our trademark guys will often recommend performing some freedom to use analysis before launching a trademark to check that you don't have to undo all that good work you're about to do. So timings. When can I use your trademark? Well, you can use it whenever you want. You don't need to worry about publicly disclosing it before registering it. You can put it out there whenever you want. Although it's recommended to perform a search before you launch under that trademark to check that you're not infringing another third party's rights. Trademarks can last indefinitely, in contrast to patents and designs, which had a limited lifetime. And these rights require renewing every 10 years. So you could register your trademark. There are advantages to doing that. It provides you with an automatic exclusive monopoly right. You will specify the classes of goods and services to which your trademark applies. So that is where a trademark attorney can help you by having familiarity with the classes of goods and services that are out there. I'm not a trademark attorney, I'm not particularly familiar with them, but I know they relate to, you could say, perhaps furniture or office furniture. That might be a class of goods, but it would mean you couldn't stop people potentially from using the trademark on marketing literature, maybe. So your trademark team would be able to help you get an appropriate definition of those classes of goods and services. You obtain protection even if you're not using your trademark, but you have to be aware of non-use provisions, because if you don't use your trademark, you could lose it. It's much more cost effective to enforce than passing off, which is an unregistered right, which will be the next slide or two. Your registered trademark can provide a good deterrent factor, and you can use the R in a circle sign to show that it is registered. You can't use that sign if your trademark is not registered. So an unregistered trademark can be acquired through simple use of your trademark. You can build up a reputation in your trademark and therefore try and enforce that unregistered trademark under passing off or unfair competition. Again, since you get this for free, there are downsides. And the ingredients to succeed in such an action is that you have to show that you've acquired a reputation through use of your mark. You must show that there's been a misrepresentation by the other side. You must show that there has been confusion in the marketplace or likelihood of confusion, and that there has been damage or likelihood of damage. Now, I'm sure you can see that in order to prove all of those things, there's going to be a lot of evidence, a lot of factors that come into play, lots of arguments to be had on both sides. That can be costly. So that's why we say that a registered trademark is much easier to enforce, because you don't need to rely on meeting these criteria. But nonetheless, if you don't have a registered mark, this is available. And in this instance, you can use a TM to show that you're intending to use it as a trademark, but these unregistered rights are not recognised in all territories. So use of trademarks, you need to use the R or TM sign correctly, depending upon whether the trademark is registered or not. You can refer to trademarks on packaging and literature, and you might want to avoid descriptive or generic use of the trademark, because if your term becomes a generic term in the art, then you can lose your trademark rights. So I understand sellotape used to be a trademark. The company that owned that trademark did not enforce it. They enabled everyone to call their sticky tape sellotape, and therefore they have lost their rights in that trademark. There are numerous other examples. So as an example here, you might want to, or might not want to, when talking about your Dyson vacuum cleaner, just say Dyson's the best. You want to make it clear that Dyson is your trademark, and it's a trademark for a type of vacuum cleaner. So a flag to be waving here is potentially you want to be monitoring for unauthorized use, because if you acquiesce to other people using your trademarks, if you allow them to get away with it, that can count against you. So one way of monitoring is to perform a watch on various registers and other databases and sources of information, and that may cost a few £100 per year. With all these things, you've got to work out what's value for money for your business, of course. So where might you register your trademark? You can register them nationally. So in the UK, it should cost less than £1,000 or so for 10 years of protection in one class of goods. Many small companies go for 3 classes of goods, so an additional 2 would be an extra £300 or so. If your market is broader than the UK, there's a EU right, although that's going to change in a few weeks. But just to give you an idea, currently that will cost less than £2,000 for up to 3 classes. And if your market is further afield, again, there is an international system which covers 97 countries, and you can pick and choose which of those countries you want to cover with your international trademark, and the costs are likely to be about £1,500 plus a few £100 per country. So I said in relation to patents, your international patent will never result in or your international patent application will never result in a granted international patent. This is different. This will result in an international trademark in the countries that you select. So conclusions. There are different types of IP to be used for protecting different things. Patents for inventions, designs for the appearance of products, and trademarks for branding. IP can be useful for more than just asserting against a competitor. So the argument of I'm never going to spend the money to go to court shouldn't be the only thing that you consider when deciding whether or not to file a patent application. And a particular benefit of IP for startups looking for investment is that by filing for registered intellectual property rights, you can build up a suite of rights as tangible assets that an investor can recognise and ascribe a value to. So I'm happy to take any questions.
Great, thank you very much. Now, a couple of quick questions. In the room, questions from me first, my turn. In the room, Ian here is an academic. Is there anyone else that's an academic and their business relates to their research? So, Potter Clarkson are the lab's patent partners. For you guys, you have the IP office, and we have 2 representatives at the back. Do you want to come forward?
Yeah,
If
sure.
you've got any questions that are relevant there. So, for you guys, your questions will be generically around that, but your path is different. Any questions, please, Mustafa?
Yes, please. It's 2 questions really. Is the protection for the manufacturer countries or is it for the selling countries?
You will have to make that decision. So a patent is territorial, so you will need to choose the countries that you want to protect in. You may choose manufacturing countries, you may choose the market, where the market is. You may choose some intermediaries, but you will need to pick and choose the countries in which you want to potentially enforce your patent. So if your product has a strong manufacturing base in China, let's say, you may consider a Chinese patent. If your market is likely to be Europe-wide, you may consider a European patent application and then picking and choosing countries later on, depending upon what the process is at the time. That's under discussion at the moment. But you need to pick and choose your countries based on your commercial objectives.
Not on that particular issue, probably very quickly, I'll just give a bit of a sort of intro. My name's Paul Conley from the IP portfolio manager for the university. I manage the patent applications that are filed on behalf of the university. Just to make you aware, as Steve's already mentioned, staff have certain sort of requirements around the filing of patents for their technologies. Also, PhD research students and any postgraduates doing research degrees also have issues around sort of notifying our office around patent management and things like that. Obviously, we're not looking to restrict anybody, but we do need to sort of work with you on in terms of sort of the patent process and things like that. So I'm happy to address any questions in that particular area. Just thought it might be useful to give a bit of context about what we do.
So if in doubt, ask, and that's why on the application forms to competition we ask you to say whether it related, so we can pick up that afterwards.
Yeah.
Keith?
Yeah, just picking up on really the patent side. You were saying about disclosure, like through conferences and various other things, but that wouldn't, if you had a product in the States, as far as I'm aware, and you wanted a patent in the States, you could actually sell your product for a year before you even put an application in. So you can actually have this 12 months. So I think that was the actual market you wanted to go into.
That's right.
It didn't really matter about the UK. You could just really go into the US, sell your product for a year and think, well, it's worth patenting. Because over there you can have a patent and someone else can actually fight against you and win in court if they can prove that they've had the idea before. Is that right?
In part. So there is a grace period in the US, a 12-month grace period, and a handful of other countries. Of course, once you make the decision to use that grace period, you are cutting off your avenues, your options in other countries, such as Europe, where no grace period exists. But if your only market is in the US,
then say, it's
yeah.
not to do with that. It's not to do with other things because the UK is very much quite strict. And another quick point is about this EU thing that you were saying about the trademarks. I mean, all of a sudden England do come out of the EU. Would that still be relevant?
Well, it could well be relevant if you want protection in the EU, whether or not we're in it.
Yeah, but it wouldn't protect you in the UK then.
But an EU trademark then wouldn't protect you in the UK.
Yeah, that's what I'm saying, yeah.
Yeah, so you would need a national right as well if you wanted protection. And I'll just pick up on your point about the US, because it's quite a detailed one, so I'll try and give a high-level answer about somebody came up with the invention before you.
Yeah.
The system changed 2 or 3 years ago.
That's what I'd ask.
Yeah, so it used to be the case that it was the first to invent in the US, and that was different to everywhere else in the world. And they still have aspects of their patent law which are different to everywhere else in the world. But in that respect, they are coming more into line with the rest of the world and saying it is the date on which you file your application which counts. So even if you've got lab books that show you invented something beforehand, if you didn't disclose it, it's not prior art. And if you didn't file a patent application before the other guys, then you'd probably be too late.
Mary?
At what stage would you recommend filing a patent in the design process, and as well looking at the broader picture with more boot patents?
Yeah. It's a really good question, and not an easy one to answer, because products will evolve, undoubtedly. When you file your application, you can only include the information you know about at that time, of course, and developments might happen after that. And by filing your application, you draw that first line in the sand and you started that 12-month clock ticking. And that 12-month clock is a period during which you can file priority claiming applications. So in addition to being able to file overseas and benefit from your first date, you could potentially file a kind of top-up application with your developments included. For the initial material in that top-up application, it'll be judged as of day one. For the developments, the new material, they'll be judged as of the date of your top-up application. So there's going to be a point when you need to draw a line and say, well, I need to file my application now. If it's going to be publicly disclosed, that makes a decision for you. If you've come up with a new whiz-bang concept and you think, I really want to protect this, other people are working on it, I want to get my line drawn in the sand as soon as I can, then that's perhaps a pointer to going earlier. I guess I'd encourage making conscious decisions as often as you can, as to when to take the plunge, if you like. But there's no one answer to that, I'd say.
Anything in particular how you guys handle this?
At the university, we quite often file top of filings for exactly the reasons that have just been outlined. Very often we have to file very early because obviously our academics and researchers want to publish is moving through to them in terms of grant applications. So we often have to file a bit earlier than we would ideally like to, and that 12 months gives us the opportunity to generate more data, both for inclusion in potentially a PCT application or a separate top-up filing. So it's that flexibility we find it very useful at the university.
And one cautionary tale, one of our businesses, a guy called Alec Machin, so his product, which we're again going through due diligence with, hoping to invest in, because of product design show, because of RSA, because of all these things, it was put into public domain, which has affected his ability to protect it in the EU. So do think about what you're doing. It's great to get stuff in shows, it's great to get stuff out there, but if you don't want to do anything with it, that's fine. But if you do, just think about once it's out there, that's it, it's gone. And you do need to think about that. Also, when it comes to the competition, everything you send in to us will be confidential. The pitches will be confidential, the judges will sign non-disclosure agreements, so that's fine. But even so, you're going to have to talk to people about this, selling something. So get a pitch which talks about, which doesn't give away the value, but you can still talk about, and what advice would you guys give about how do you talk about something without giving away the value?
Yeah, so
Yeah, I mean, just from the university perspective, what we tend to do is try and generate non-disclosing statements which give a good flavour of what the technology is or what you're trying to protect, but don't give the game away. And quite often we will consult people like yourself, patent agents, about whether that particular statement could cause us problems or not. So if in doubt, whether your statement or your promotional product or whatever you're trying to advertise could be a potential problem, I would recommend running it past the patent agent just to get that security that you know what you're doing.
I agree entirely with that. And what we'll be asking ourselves, and this isn't always an easy question to answer, is what you're planning to disclose, is that an enabling disclosure? Does it enable the recipient to work your invention, or does it not give them enough information? So for example, you might just tell them the end result and not your invention of how to get to the end result. Now typically, as patent attorneys, we're a cautious bunch, and we'll say, don't say anything to anyone. And if you really have to, get a non-disclosure agreement. But equally in the real world, that's not always possible. So the next best would be to...
It's just trying to strike that balance, isn't it? Yeah.
So again, for academics, go and talk to the IP office. For product design students, what will be happening later this year is Potter Clarkson will be coming in and talking to you guys at an earlier stage than it's happened before. So you'll have this information there. Yes? Just at the back.
Two questions. How does one find out if a particular patent has been granted in multiple countries? And if that said patent, for instance, was granted in Europe, and if another group wanted to use that patent, wanted to commercialize it in some Latin American country, is there any reason we couldn't buy system components from Europe, say, and get it over to Chile to use it?
Okay. So I'm assuming you have a patent in mind, so there's no searching involved here. You say, I've identified this European patent, whatever it may be.
Yeah.
There's a very easy way to find out where that same invention has been pursued overseas.
Okay.
Patents are grouped together in what we call families. So that family may well involve applications in many, or patents in many different countries, and there's a database that we can use to look where else that same invention has.
Is there any way that people have been,
Yeah,
people such as myself,
absolutely. Yeah. So on the slide where I talked about searching, I think I've
e-space stuff.
exactly. So if you plug the patent number in there, and then there'll be a button. I think it says View Inpadoc Patent Family, or words to that effect.
It's very clearly marked. Yeah.
Now you need to be wary, of course, that a patent protects what's covered in the claims, and it's not a routine or straightforward thing to read a patent document and say, this covers X, Y, and Z, and similarly, this covers or doesn't cover my product. The ultimate test will always come down to local law and how that local court interprets various terms and phrases and how the claim should be read. So it's not straightforward, but you can certainly identify other countries where it's been pursued. Another thing to mention is that just because it shows up Chile doesn't necessarily mean they've got a patent granted in Chile. You'll need to follow that through and check that it has indeed been granted. They might have applied and then pulled the plug, so they don't have any rights there.
Okay, so it is possible to commercialize it in Chile.
So yeah, so if that patent is only in force in Europe, just as my territorial slide at the start, they should not be able to use that European patent to stop you if you manufacture and sell in Chile. If you manufacture in the UK and export, then you could have a problem.
Do you have a question? Yes.
The question was, how many times after you file it, how many times can it be changed? I don't know where that can be changed.
Okay, it depends what you mean by changed. So once you've filed your application, you cannot add any new subject matter to it. So as I say, you've drawn your line in the sand, you've made your bed, you need to lie in it. But any material you've included in that initial document, potentially you can include into your definition of the invention, your claim 1 later on, and that's very common. So although we will draft claim 1 to define your invention in the broadest way we can, we will have fallback positions, in part by way of dependent claims, so that if a patent officer says, okay, well your claim 1's all very nice, but it's been done before, we can say, well, look at our claim 2, that adds an additional feature to our definition of the invention. So our protection has got narrower, but by doing that, we are now novel and inventive over the prior art. And there can be variations from country to country, but as to the number of times you can amend the claims in this way. But you shouldn't really see that as a barrier, I would suggest. Certainly in the UK and Europe you can, well, I don't want to say you can have as many goes as you like, because the patent office will eventually say, come in and speak to me, and we'll make a final decision. But you don't need to worry about that being a restriction, apart from adding new matter.
Yeah, and obviously you've got that first 12 months, what we were talking about before with the top-up filings. So if you wanted to add a new aspect to the invention, you could file in that 12 months, and then if you take it to the next stage, claim priority from both. But the important thing is that you would then have 2 separate priority dates effectively. One for the very first filing with the core invention, and possibly a separate priority date for the second part of the invention. The examiner might consider them separately.
Right. Well, my question is related to the patent protections in different countries. Let's say I built a software and it's patentable, and then I got mostly worldwide protected except France, and then somebody in France made that software. Well, he sold the software within France, but then his client used that software everywhere else worldwide. So how's the patent protected in this kind of case then?
There's no easy answer. There is case law on that point, and it was to do with the UK patent and a bookmakers, maybe William Hill, perhaps Ladbrokes. They moved all their servers to the Caribbean somewhere in an attempt to get around the UK patent, even though the software was then being used in the UK, and they didn't get away with that. So it's really going to vary from country to country, and you will need to choose a country to enforce where you do have a patent, and then seek to build a story, build a case as to why your patent in that country has been infringed. But it's not an easy question, not an easy answer to that question.
Yes.
If you have a product which is, of course, made up of the product, but also an app or a piece of software that runs the product, do you have to file a patent for the product and then a patent for the software that runs the product, or can they be combined?
Good question. You don't have to file anything. If you wanted independent protection for the product and you wanted independent protection for the software, you would need 2 patents. Now, you could initially file a single application that described the whole system, perhaps have an independent claim to the product, so it didn't talk about software at all, and therefore a competitor would infringe that product, that claim, if they made a similar product, and it wouldn't matter what software they had. You could also have an independent claim potentially to the software, irrespective of the product. So a competitor would infringe that claim if they supplied similar software, and it wouldn't matter what product it was in. Now, most patent offices won't let you have independent protection for more than one invention in the same patent, in the same granted patent. You can start off the process with a single application, so your day one, but somewhere along the line, most patent offices will say, hang on a second, you can't have two for the price of one here. You need to branch out and file a new, what we call a divisional application. You need to divide out one of your inventions into a new application. You still benefit from your date number one, and then you can separately pursue protection for that invention. Does that answer your question?
Yeah, I mean, the other thing you might want to consider in that sort of circumstance was touched on very well in the talk was other forms of protection as well, so things like trademarks and copyright around the software. Firms will usually build up layers of protection. So for example, I used to work for Alliance Boots over at their head office, and normally their products that they sell in their stores will have things like trademarks around them, they'll have patents around the formulations in them, they'll have copyright around the instructions on how to use the products and things like that. So you take a sort of holistic approach and try and build up layers of protection. If you're trying to market your product, that's probably a good way to look at it.
Yes.
Where can I search for registered software designs?
Ooh, now, depends what you mean by registered software designs.
So, when you mentioned colors,
okay.
I want to investigate the extent of like the use of colors by a certain company.
Okay, so you could be referring to a trademark, because a trademark can be used to protect a colour. You could be referring potentially, I guess, to a design, if you're saying that the design is protecting a colour. The trademark registry, the UK trademark registry, has a search service. I don't work in trademarks and design, so I'm not as familiar with those websites as I might otherwise be.
But they exist.
But registries exist, and to varying extents they have search functionalities or search functions.
There's the OHIM website, isn't it? For the CTA, for the community trademarks. That's a good, if you've got a word or a colour or something like that, there is the possibility to search on there for it, and it will give you an idea of what's out there. Obviously, probably the best thing to do is if you're going to go into it serious, to seek sort of professional advice and get a feel, especially when the costs are fairly minimal, and probably give you a clearer answer than possibly a freelance rate search for a patent would do.
Yeah, and I think that's an important point, that any decisions you make yourself clearly have risks associated with them.
Yeah.
Ernest.
To be able to register a trademark, do you have to have a registered company?
You need to have a legal entity in which that will own the registered trademark.
Can a founder own the trademark right and then sell it to her company?
Yes, you can sell trademarks. Yeah, it's
As a person, absolutely.
yes, yeah. I mean, there are downsides to doing it in your personal name. Any liabilities or anything that goes wrong might result in you personally being liable. Whereas if you open up a shell company, which can be done pretty cheaply, all that risk is then put on the company and not your personal head. But I'm not aware of any reason why, an individual can apply for intellectual property. Absolutely.
Agree.
Yeah. What kind of protections could you get if you'd come up with like a service or a process?
Service or a process, potentially a patent, depending upon what the service or process is. And for the service or process, I think that would be the only option available to you, because it wouldn't have an appearance that you could protect as a design. The brand or the trademark would be something different. It wouldn't protect the service or process itself. So I think we're looking at patents. Potentially, if it's a software process, copyright will exist automatically. I won't steal Ed Wright's IP thunder here from. There's a very good IP solicitor coming in a week or so to talk to you about more the solicitor side of IP. But I think what we would probably be focusing on to start with is whether or not your process does something technical, assuming it's software based. Yeah.
So lady at the back, she's very
If my competitors have similar design or appearance as my product, but the only distinguishing feature and also the most central part of my product is the user interface, am I supposed to file for a design protection or just a normal patent protection for the whole product or just for the user interface?
From that example, I'd suggest if you could get a patent for the user interface, that would be a good thing to get. And patents for user interfaces are available. They're not straightforward because it's going to be software related, I'm sure, so we need to show that there is some technical advantage in that user interface. Whether or not design protection is available or not, lots of factors will come into play, such as the freedom with which the designer has to alter things, how crowded the marketplace is. The ultimate test is to show that your design creates a different overall impression on the end user. So that you've got to put yourselves in the shoes of that end user, look what other products are out there. If there are tons and tons of them, then it could be that a very small difference could make a different overall impression.
Any more questions? Yes.
So my question is whether the online service can be a patent as well. I mean, if we come up with a new idea that's based on the online service, then is there anything we can do to prevent those rewriters joining the competition?
A what service, sorry?
Online service.
Online service?
Yeah.
So computer software, presumably.
It's not like a software.
So what would the invention be, would you say, potentially? What would be different?
I think it's something like related to our business model, but we're not producing like the real product or like creating like the new like technical things. So.
Okay. I think that would need to be explored further. At the moment, I'm wondering if there is some software behind the scenes that you're saying is what's causing this online interface to be different, perhaps, or this online service.
might be some sort of algorithm or something.
There could be an algorithm which automatically will have copyright protection, but that's quite limited.
I suppose you've potentially got database rights as well, which I presume will be picked up at them.
Yeah, but certainly from the topics we've been speaking about today, I'm struggling to fit that into one of those boxes without further information, based on what we've said so far.
Last question.
Well, it's related to her question. Can a business model be patented?
Probably not. The legislation tells us that business methods as such are not patentable. Now those words "as such" are key, because that gives us lots of scope for arguing when a business method is not a business method as such. And it's the same with computer programs. The way the law is developed in Europe, and this is an area where the US is slowly following suit, is that the invention must do something technical. And a patent office is almost certain to say that if your distinction or if your clever bit is a business method and it's a method of hedging investments, in this case law on that, then that is a business method as such and you can't get a patent. If you merely implement that business method on a computer, that doesn't get you over the line because you're either a business method as such or a computer program as such. You're not doing something that is technical, you don't provide a technical advancement. Now, we get cases in where we have to try and argue that quite dark colours are white, when you say black is white, but and we have to come up with creative arguments as to why, well actually, putting this business method on a computer is more than a mere implementation. We've done it in this clever way, it reduces the computer resources required, it results in more secure transactions perhaps. These are examples of things that are probably technical, but if it's, as I say, financial instruments, we often struggle with those.
So, before you go, if I could just ask two of you to summarise. If you're going into this with limited budget, what would be the sort of key points to think about, to summarise?
I'd say making conscious decisions. You don't have a bottomless pit of money, clearly.
Yeah.
But to make conscious decisions as you go through as to when you've got a good argument that it's value for money, what things can be postponed and what can't. So if you're going to publish your invention, that's, apart from the US and various other countries, that is your full stop. You need to decide there and then. And yeah, I think making conscious decisions, and every business is different. It depends on your plan and what you're doing as to what the best flavour of IP, if any, is.
Yeah, I totally agree with that and pick up on it. I basically sort of add that any form of IP you're looking to either enforce or get granted, you have to have a clear idea of why you want it and what you're going to use it for. You can have as many patents as you like, but if they don't actually provide any useful function, all you're basically doing is racking up a lot of costs that you could potentially spend developing your business or other aspects of that. You know, obviously there are low-cost options around things like copyright and database rights and things like that. So a patent might not always be the best option, but obviously it gives you very good protection if you do get it granted. So make conscious decisions. I think I totally agree with that. Yeah.
Brilliant. Thank you very much. Thank you.